Time for analysis. Let's bring in John Malcolm, Senior Legal Fellow at the Heritage Foundation. John, good to see you again. Talk to us about the significance of this case and your key takeaways from today's oral arguments.
Well, this is the first time that a state has tried to disqualify the leading presidential contender for one of the major parties, not to mention a former president of the United States, by invoking the insurrection clause, by saying that basically he is an officer of the United States who engaged in an insurrection. He had previously taken an oath to support the Constitution, and he is therefore disqualified. I don't think that argument went over very well today at the Supreme Court. It's always perilous predicting the outcome of a case from the arguments, but I feel fairly sure that there are at least 5 votes to overturn the Colorado Supreme Court, and it would not at all surprise me if it ended up being a unanimous decision. I think the justices were receptive to the argument that a president does not qualify as an officer of the United States under Section 3 of the 14th Amendment. I think they were receptive to the argument that that clause is not self-executing, that requires federal legislation to implement it. And I think that they were deeply distrustful or troubled by the fact that you could end up having 50 states using 50 different procedures, each one making a determination about who is qualified and who is not qualified to remain on a ballot and serve as president of the United States.
John, I want to talk about this. I'd venture to say that not many Americans are really familiar with Section 3 of the 14th Amendment. Can you dive into that quickly a little bit and tell us why Colorado is using that as the basis of their case?
Sure. So the Section 3 of the 14th Amendment, it was ratified in the immediate aftermath of the Civil War, and it was very clear that the main intent behind that was to prevent the Confederate states from electing officials, either state officials, judges, federal officials, and having them serve. So it basically said if you had taken an oath and you engaged in an insurrection, you are disqualified from holding office unless Congress grants you amnesty. Congress ultimately did, by the way, end up granting amnesty to all the people who had previously supported the Confederate cause, but that did not happen for several years. And I think the concern is that the Confederate states were going to elect former rebels. They did, in fact. The vice president of the Confederacy, Alexander Stephens, was elected back to Congress. And I think that was a concern. And so one of the arguments that seemed very strange to the justices is that this provision was designed to give the federal government more power over making those decisions, not empowering each state to make those decisions.
John, almost out of time, but really quickly, what comes next and how soon do you think we'll see a decision?
Well, now the court's going to meet in conference tomorrow to decide how to decide the case, and I think they will issue an opinion very quickly. Usually in the most contentious cases, they don't come out until the end of June. It would not surprise me if this opinion does not come out. It would not surprise me if it comes out before the end of February. The justices are very well aware of the fact that the election season is underway, and it's important that they decide this case quickly.
All right, John, thank you so much for your insights. Appreciate it.
Good to be with you.